My name is Nicolene Schoeman-Louw, and I'm an attorney, conveyancer, notary public, and mediator. I practice as such at Schoeman-Louw Incorporated, based in Cape Town, South Africa, where we proudly serve the legal needs of the entrepreneur. I'm also the managing director of Schoeman-Louw Incorporated, and I've been practicing law this year for 14 years. In addition to my LLB and LLM, I also hold a postgraduate diploma in financial planning, and as such have focused on the area of law involving the administration of deceased estates and estate planning, including the drafting of wills. It is against this backdrop which I would like to use the opportunity to share some insights with you and some tips for the upcoming attorneys admissions exams. Firstly, when we are speaking of administering deceased estates, broadly speaking, there are two procedures to follow. One is the abridged procedure, if we could call it that, where only a few compliance elements are required, and that is the Section 18, subsection 3 estates, or small estates. In this instance, the person appointed by the Master of the High Court is referred to as the Master's representative as opposed to the executor or executrix. Other estates are run by the normal course, and the person appointed, as I've mentioned, is either referred to as an executor or executrix. It is important that you understand these two processes and how they differ from one another, not only for preparation of this examination, but also for practice. In addition to that, it is also useful for you to look at as many precedents of clear drafted wills. If you are drafting a will, remember, this is the most sensitive document that person, and probably also you, will be drafting in your lifetime. Why? Because unlike a contract or any other legal document, it cannot be scrutinized by way of explanation. It becomes legally binding and effective when you are no longer there to explain what you meant. So clear, concise, simple, plain language drafting is absolutely critical. Think carefully, keep your sentences short, get to the point as to what you want to do and how you want to word what you are including in your will, or in the will that you're going to be drafted for your client or as part of the admissions exam paper. That is absolutely critical. Now, I know many of us are fearful of the word liquidation and distribution account. Don't be afraid. Stick to the basics. Look at how you divide your account. Memorize the segments and some of the categories that are placed under each of them. And then complete your amounts and make sure that you do as many of them as you possibly can. If you've had the added advantage of having to administer a deceased estate, whether a Section 18.3, but particularly a larger estate where you would have had to draft a liquidation and distribution account, it will most certainly stand you. My name is